The Supreme Court heard arguments in the most significant abortion case it has seen in a quarter of a century. And it's also the first major case since the death of Justice Antonin Scalia.
The remaining 8 justices will decide whether a Texas law violates a woman's right to have an abortion. Dahlia Lithwick is a courts and law writer for Slate, and she joins us now to talk about all this. Dahlia, thanks for being here. Can you explain a little bit more in depth what this case is all about and what people are protesting?
Sure. In effect, you remember Roe versus Wade, and it upheld the right to an abortion under privacy theory. In 1992, the Supreme Court refined slightly the test in Roe versus Wade. They maintained that we do have a right to get an abortion, but that the states can regulate certain abortions, but they cannot place what's called an undue burden on a woman's access to abortion. The question arises in this case because Texas, as you'll remember, in 2013, passed the famous HB 2, that was the Wendy Davis filibuster law, and 2 provisions are at issue today. One is that doctors need to have admitting privileges at nearby hospitals in order to perform abortions. The other is that every single clinic that performs abortions has to be retrofitted to be what's known as an ambulatory surgical center. Those 2 things have forced 40 clinics in Texas to become 20 clinics, and if the law really goes into effect, it will be 10 clinics. So the issue is for the court, does that constitute an undue burden on a woman's right to abortion if she has to drive, for instance, 200 miles in either direction in order to get an abortion?
So, Dahlia, according to the New York Times article, several justices seemed very frustrated by the factual. There were gaps, they believe, it seemed, in the factual record presented to them. And actually, Justice Kennedy mused that it might be useful for them to return the case to the lower court so that those gaps can be filled in. So why not do that while they are missing one justice there on the panel?
That's certainly a possibility. We always knew that if this was going to be a 4-4 outcome, it was going to mean that the law in Texas got to stand because the Fifth Circuit, which is the lower court opinion, is the law in that jurisdiction. It has no precedential value, and it's not the law anywhere else. So that's very confusing to have abortion law be one thing in one state, a different thing in another state. So one solution to that problem is to just kick it back to the lower courts and say, find something different, look at this in a different way. And certainly I think Justice Kennedy, and don't forget, he becomes that 5th vote, I think, if he aligns himself with the left-leaning justices, was making noises like he really did want to kick it back to the lower courts in Texas to have a more vigorous and zealous finding of fact. And it has the added benefit of meaning that the court gets to hit pause on this case and look at it again, hopefully with 9 members.
Dahlia, in the New York Times article that Christine was referencing, it points out that that this law, if it goes into effect, could mean that there are even fewer abortion clinics. In other words, fewer places for women to get abortions in the state of Texas. Have there been closures of these clinics even since that prior law passed?
There absolutely have. There were about 40 clinics in Texas when HB 2 went into effect. That went down to 20 clinics. There's about 19 now. And what the clinics are contending in this piece of litigation is that if this law is allowed to stand, there may only be 9 clinics. And that means that the big cities, Austin, Dallas, Houston, will have a clinic. But there are whole swaths of, say, the Rio Grande that will have no clinic, and that women will have to drive, as I said, hundreds of miles in order to take a pill, in order to go home, in order to take another pill. And this is the kind of burden that they say the court contemplated in the Casey case.
All right, Dahlia Lithwick, thank you so much for illuminating that for us. We appreciate it.
Thank you.